What if I told you that nearly 500,000 people in a single year could have the foundation of their future pulled out from under them? Not because they broke the rules, not because they failed to contribute, but because the rules might change halfway through the journey? Right now, over 50 members of parliament, peers from the House of Lords, major civil society organizations, and one of Britain's most powerful trade unions have taken an extraordinary step. They've sent a formal letter to the Home Secretary demanding she rule out retrospective application of the proposed 10-year indefinite leave to remain rule. And buried inside that letter is a warning that should make anyone on a sponsored visa stop in their tracks. Because this isn't just a technical immigration tweak. This could redefine what security, fairness, and trust mean for more than 1 million international workers. Welcome back to GoUKGo. If you care about UK immigration policy, if you're on a skilled worker visa, if you're planning your future around the 5-year ILR pathway, this is one of the most important developments you need to understand right now. What began as individual workers signing petitions and emailing their MPs has now escalated into something far more serious. A coordinated cross-party political campaign. This is no longer just online frustration. This is Parliament pushing back. Publicly. And timing matters, because April 2026 is not far away. The consultation has closed, decisions are looming, and if these proposals go ahead in their current form, the impact will be immediate and massive. So today I'm breaking down exactly what this letter says, why the coalition behind it matters, what the exploitation warning really means for sponsored workers, why campaigners are calling the consultation process a farce, and what the April implementation deadline could mean for you. Let's start with the coalition itself, because who signed this letter is just as important as what it says. More than 50 MPs signed, not from one party, not from one ideological corner, from across the political spectrum. That alone is significant. But here's what makes it even more striking. Many of those signatories are Labour MPs, members of the governing party. This isn't the opposition trying to score political points. These are lawmakers effectively telling their own Home Secretary that her approach is flawed, rushed, and potentially unjust. Peers from the House of Lords added their names too, giving the letter weight across both chambers of Parliament. That elevates it from routine political disagreement to a serious institutional challenge. Then come the civil society organizations, groups representing migrant workers and labor rights, and perhaps most notably, Unison, one of the UK's largest trade unions, representing over 1.3 million workers in public services, signed the letter. When a union of that scale publicly challenges a Labour government's immigration proposal, it's not symbolic. Unison has long-standing relationships with Labour, political influence, organizational ties, historical alignment. Their involvement signals real internal pressure. The Home Secretary cannot simply dismiss this as noise. Now, what exactly are they objecting to? At the heart of the dispute is the proposal to double the qualifying period for indefinite leave to remain from 5 years to 10 years for most workers, and to 15 years for certain sectors, including social care, which the government has classified as lower skilled. The letter opens with a powerful framing. Thousands of families have planned their lives around the current rules. That sentence captures the entire moral dilemma. People did not move to the UK casually. They didn't arrive on vague promises. They came under a clearly defined framework. 5 years of lawful residence and contribution would lead to permanent settlement. Based on that understanding, they made life-changing decisions. They left home countries. They built careers. They paid taxes. They bought homes. They enrolled children in British schools. They invested emotionally and financially in this country. Now imagine being 3 years into that journey, or 4, or even just 1 year away from settlement, and being told the finish line has moved. The letter describes this as pulling the rug from under migrant workers, and that metaphor is precise. This isn't about changing the rules for future applicants who haven't yet arrived. It's about changing the terms for people already standing on that rug, people who entered into what they believed was a stable agreement. For care workers, the proposal is even harsher, 15 years before settlement. The letter directly challenges the classification of care work as low-skilled. It calls that designation out. Because what does care work actually involve? It involves administering medication, managing complex health needs, supporting elderly residents with mobility, providing emotional comfort during end-of-life care, offering dignity to people in their most vulnerable moments. That requires technical competence, resilience, empathy, and responsibility. To reduce that role to low-skilled is not just bureaucratic shorthand, it's a value judgment. And the letter makes clear that many MPs fundamentally disagree with it. But beyond fairness, the letter raises a more procedural issue: transparency. The signatories accuse the Home Office of pushing through sweeping immigration reforms without publishing a full impact assessment. They specifically demand a comprehensive economic impact assessment and a child rights impact assessment. Why does that matter? Because before implementing major policy changes, governments are expected to formally analyze their consequences. What will this mean for the economy? For public services? For the NHS? For social care staffing levels? For tax revenues? For local communities? And crucially, what will it mean for children in affected families? Children who have grown up in the UK, children in British schools, children who consider this country home. The letter argues that these assessments have not been adequately presented to the public. Without that data, how can the consultation process be meaningful? Dr. Dora Olivia Weichel, CEO of the Work Rights Center, went further. She called the consultation a farce and demanded it be restarted with the full picture available. She described the proposals as potentially the biggest shakeup to the immigration system in 50 years. That is not routine reform. That is structural overhaul. And if that characterization is even partially accurate, rushing it through on a compressed timeline becomes deeply concerning. Now let's talk about the part that, in my view, should concern every sponsored worker the most: the exploitation warning. Under the current system, skilled workers on sponsored visas are tied to their employer. Changing jobs requires sponsorship transfers and paperwork. It's not frictionless, but it is possible. And after 5 years, ILR provides freedom. The freedom to work for any employer, the freedom to negotiate pay, the freedom to leave toxic environments without immigration consequences. Settlement creates leverage. Under a 10-year system, that leverage is delayed by half a decade. Under a 15-year system for care workers, it's delayed by an entire decade beyond the current timeline. Imagine being tied to sponsorship for 10 years. If an employer underpays you, you tolerate it. If shift patterns are exploitative, you endure them. If promotion opportunities disappear, you wait. If the workplace becomes hostile, you think twice before speaking up, because your right to remain in the UK is connected to that job. Unscrupulous employers, and yes, documented visa fraud cases prove they exist, gain extended leverage. Instead of 5 years of control, they effectively have 10 or 15. The Work Rights Center argues that this dynamic increases vulnerability to exploitation, and that concern is not theoretical. The care sector has already seen cases of illegal recruitment fees, underpayment, coercive practices, and threats of sponsorship withdrawal. Extending the timeline doesn't automatically solve those issues. It potentially prolongs the period of dependency. Then there's the philosophical argument embedded in this debate. What counts as contribution? The Home Secretary has described her approach as an earned settlement model, rewarding those who make greater economic contributions. On paper, that sounds straightforward. But how do we define economic contribution? Is it purely salary? If so, higher earners settle faster. Lower earners wait longer. But contribution to society is broader than a payslip. Care workers reduce NHS pressure by supporting elderly residents. Teachers shape future generations. Hospitality workers sustain tourism. Cleaners keep public infrastructure functioning. If settlement eligibility becomes primarily tied to income thresholds, the risk is that essential but lower paid roles are structurally disadvantaged. And that's where the moral argument re-enters. Now let's ground this in numbers. An estimated 1.6 million people are expected to qualify for ILR between 2026 and 2030 under current timelines. In 2028 alone, projections suggest approximately 450,000 people would reach eligibility, nearly 500,000 individuals in a single year. If retrospective changes apply, that cohort could be told their wait just doubled or tripled. That scale is extraordinary. This isn't a marginal adjustment affecting a few thousand applicants. It's a systemic shift affecting a generation of workers. The Home Secretary argues that these reforms respond to unprecedented levels of legal migration under the previous government. She frames it as responsible management and moral stewardship. But here's the counter-argument campaigners are making. The workers who arrived did so legally. They applied. They were approved. They followed every rule. They paid visa fees, often substantial ones. They paid the immigration health surcharge. They paid taxes. They upheld their side of the agreement. Retrospective application means changing the terms after the fact. And when governments change contracts retroactively, it affects trust, not only among current migrants, but among future global talent watching from abroad. International professionals considering the UK will ask, are the rules stable? Reputation has economic consequences. Now let's talk about urgency. The consultation closed on February 12th. The government must analyze responses, finalize policy, potentially draft legislation, and implement changes before April 2026 if that timeline holds. That is compressed. Critics argue that major immigration reforms deserve robust scrutiny, not acceleration. The cross-party letter demands a reset, proper impact assessments, proper transparency, and an explicit ruling out of retrospective application. Whether the Home Secretary will concede remains unclear, but politically, this is the most significant organized pushback we've seen so far. Over 50 MPs, peers, Unison, worker rights organizations. That is not easy to ignore. So, what does this mean for you? If you are already on the 5-year ILR pathway, the key question is whether changes will apply only to future entrants or to those already in the system. That distinction is everything. If retrospective application is ruled out, those already progressing under current rules may continue on the 5-year track. If it is not ruled out, the landscape changes dramatically. Right now, political pressure is building. But until the government formally responds to the consultation and clarifies its final position, uncertainty remains. And uncertainty is powerful. It affects life planning, mortgage decisions, family decisions, career moves. That's why staying informed matters, because this debate is no longer hypothetical. It's active, it's parliamentary, and it's escalating. On GoUKGo, we're going to continue breaking this down as developments unfold. The government's formal response, the final policy wording, potential legal challenges, and practical strategies for affected workers. If this cross-party campaign gives you even a small sense of hope, let me know. If you're currently on the ILR pathway, tell me how this uncertainty has impacted your plans. Do you believe 50 MPs and a major trade union can influence the Home Secretary's decision, or do you think the reforms will proceed regardless? Share this video with every international worker you know who may be affected. Information is leverage. Awareness creates pressure, because one thing is certain: when lawmakers publicly call a proposal unfair and un-British, governments take notice. The next few months will be decisive. Until then, stay informed, stay prepared, and remember, policies can change, but informed communities have power. This is GoUKGo. I'll see you in the next one.